Mr. Mchizana. I apologize, Your Worship. Your Worship, this is the first appearance in this court. The charges are as per the charge sheet. The state and defense agree that the matter for bail ought to be heard in terms of Schedule 6 based on the type of charges that the accused is facing, particularly in respect of count 1, which is a contravention of Section 14 of the POCTA-DARA, or the Protection of Constitutional Democracy Against Terrorist and Related Activities Act 33 of 2004. The state is not opposed to bail.
Just one moment before you proceed. Mr. Duduzile, Zuma-Sambudla, you may be seated. Sorry, Mr. Kenyan, you may proceed.
Thank you, Your Worship. The state is not opposed to bail in this matter.
Yes.
The bail is to be heard in terms of Schedule 6, as I have explained, Your Worship.
Yes. The reasons as you obliged to place on record for non-opposition.
Your Worship, we have verified.
Sorry, do you not want to deal with the issue of the televising of the proceedings?
Indeed, Your Worship. I think that there was an application brought.
Yes. Mr. Nkoku, have you had sight of this application, the Veritas application?
No, I haven't, Your Worship, but if it's the standard one, then
This seems to be a standard one.
Yes.
Very generalized.
yes.
No objection from the state, Your Worship. We are.
Thank you.
We have no objections.
Just in respect of that application for the televising of court proceeding, what authority do I have to grant that? Just very briefly.
Your Worship, I would assume that it is in the discretion of the court. It has become a practice these days in all of our courts, including our superior courts. All right. And at the end of the day, we all subscribe to the view of an open justice system where justice must be seen to be done.
Thank you, Mr. Nkoku.
As God pleases, Your Worship, yes, no, we have no objection at all in respect of that application, and I agree with my learned friend that it's a matter of that is within the discretion of the court, and whatever conditions the court might place will be in the discretion of the court. At this stage, we have no objection.
Thank you.
As God pleases, Your Worship.
Thank you, Mr. Nkoku. Yes, you may proceed, Mr.
Your Worship, as I indicated earlier, the state is not opposed to bail.
Yes.
The reasons that we have decided not to oppose bail are the following. Your Worship, the address of the accused has been verified. It is recorded in the affidavits. The accused is an employed person, and we have verified the employment. More than that, Your Worship, the accused was aware of the investigation and made comment regarding it some 2 years ago, and is still available and cooperated fully with the state as far as being present in court is concerned today. Even though the accused appears, as it must be in terms of our law, in custody, I can place on record that she handed herself over willingly to the police this morning, and she was processed and brought into court for these proceedings to be held. And on that basis, Your Worship, we do not oppose bail.
Sorry.
We do not also consider her to be a flight risk.
Yeah, just one moment. You say that as she was supposed to in law appear before this court.
Your Worship, the accused is being arrested in terms of a charge that falls within Schedule 6,
Yes.
which gives the court a discretion regarding bail issues, which is why she has been brought after handing herself over to be before the court, so that the court can determine or make a proper determination on the bail issue, despite the fact that the state does not oppose.
So was the applicant then arrested? You understand?
Yes, she was arrested, Your Worship. She was placed under arrest
With
this
a
morning.
warrant or without a warrant?
Without a warrant, Your Worship. We contacted her through, I think it was through the political party officers at first,
Yes.
and then we got contact with her legal representatives, and arrangements were made for her to be brought in this morning. which she did, and she presented herself to the investigating officers who went through the process of having her and the matter placed in the court.
I asked that because it seems to me from your address there's a bit of conflation between the two processes. One deals with the arrest, which is a separate process, and then the issue of admittance on bail or otherwise, which is also a separate process, which is within the discretion of the court.
Your Worship, we did not want to deprive, if that is the word, the court of that discretion, which is why it is customary for us as the prosecution, when a person is charged in terms of Schedule 6, to place a person before a presiding officer in custody. For a presiding officer, as the law requires, to make the determination in the bail process as to whether the onus on an applicant in a Schedule 6 application has discharged the onus of presenting exceptional circumstances in the interest of justice. And it's a process thing that we have, and in the end it's your Worship's discretion regarding bail. The state, as I indicated, is not opposed to bail in this matter. Further to that, your Worship, we have assessed that the accused is not a flight risk, and the likelihood of any interference with witnesses is minimal. We have taken certain precautions regarding the witnesses, which gives us reason to believe that we do not have a fear in that regard as well. Those are my submissions regarding the non-imposition of bail.
Thank you, Mr. Yu.
As the court pleases.
Thank you, Mr. Bova.
Thank you, Your Worship. Yes, Your Worship, I confirm that I appear for the accused in this matter, instructed by my attorney, Ms. Tina Africa Mpumbana. Yes, I do confirm most of what my learned friend has informed the court. Indeed, my Lord, Your Worship, the arrangement is as was outlined by him, in that the investigating officer and I had the first contact, and then I also had contact with my learned friend. So the process that was followed this morning of the formal arrest, as it were, was done to that arrangement. Yeah. And now we have then come to this process. And to the extent that the matter is presented as a Schedule 6 offense, we also agree, Your Worship, that then shifts the onus to the applicant or accused, such as it were. And we therefore, with the direction of Your Worship, at the correct time, would be in a position to read out the affidavit onto the record. Fortunately, the attitude of the state has already been outlined to the court, and therefore we would really just do it as a matter of formality for the record. As a court.
Thank you, Mr.
In other words, Your Worship, sorry, Your Worship, then therefore the implications of that the matter would then falls under Section 60(11)(a) of the Criminal Procedure Act. As a court basis.
Thank you.
As a court basis. Your Worship, I did hand up in chambers a copy of our application in terms of Section 60(11)(a) of the Criminal Procedure Act 51 of 1977. If I may, Your Worship, can I just go to the affidavit before I go to the notice of motion?
Yes, certainly.
As court basis. Your Worship, also with your permission, if I may be permitted to leave out some of the personnel details, but obviously they are as reflected in the affidavit.
Yes,
as court pleases. It reads as follows: I, the undersigned Duduzile Zuma-Sambudla, do hereby make oath and state that I'm an adult female born on the dates that are outlined there. I'm the applicant in this application for bail pending my trial. Facts are within my personal knowledge unless stated otherwise, and to the best of my belief, true and correct. When I make submissions of law, I do so on the advice of my legal representatives. whose advice I accept. And the content is as follows, Your Worship. For the convenience of the court, put it in separate headings to deal with some of the requirements of the law. I'll start at paragraph 4 then. I have been charged with incitement to commit the offense of terrorism and incitement to commit the offense of public violence, the exact details of which are unknown to me, but I understand these charges and the seriousness of the same, and I intend to plead not guilty thereto. That is when the trial starts. 5. Although I have not yet sight of the complaint or the summary of facts, I'm aware of the long-standing rumors and innuendos about the messages which I sent from my social media accounts, mainly on the Twitter platform, in connection with the general uprising which had already erupted in KwaZulu-Natal, in the KwaZulu-Natal and Gauteng provinces, in reaction to my father's imprisonment in July 2021. Although I do not deny having sent some messages which have been misconstrued, I am of the strong opinion that no court can find that the violence in question occurred as a result or in connection with any incitement or any conduct on my part. The two things are utterly unconnected, causally or otherwise, in any sense envisaged in our criminal law. My conduct was only informed by my particular sense of outrage at the injustice meted out on my own father. This went much further than the objections of his political supporters and millions of other peace and justice-loving South Africans who, like me, did not participate in any acts of public violence, either directly or indirectly. I also hold the strong view that the charges are malicious and politically motivated. They are aimed at settling political scores with my father by the current regime. Evidence in this regard will be led during the trial. Suffice at this stage that I am confident that a case of malicious prosecution will be well and easily established against the National Prosecuting Authority at the appropriate stage. I have instructed my legal representatives to pursue that action. 9. It is plainly nonsensical and petty to interpret words which are used, such as, quote, I see you, unquote, to mean that the people referred to or were influenced by my social media commentary. The mere fact that it has taken the state almost 4 years to work out whether a small number of social media messages constitute, quote, terrorism, unquote, speaks for itself and is an indication that the NPA is clutching at straws with a very weak case. 11. I have been informed that the charges proffered against me constitute a Schedule 6 offense and that I bear the onus to prove on a balance of probabilities that there are circumstances, that there are exceptional circumstances, so that's what it should read, and that the interests of justice require that I be granted bail. Then the facts were placing before the court. In this regard, I wish to place the following facts before this court, this honorable court. I'm currently residing, I'll also limit the headings in as well, just for the record. Permanent residence, movable and immovable property. I'm currently residing at the address indicated there, where I have been residing for 13 years. The property belongs to the company that's mentioned there, a company owned by my estranged husband. I do not own any immovable properties in my own name. That place. I was born in Mozambique, in Maputo, and I am a South African citizen. My ancestral home is Kwata Duduzile, Ngandla, in the province of KwaZulu-Natal, where my father currently lives. Then under the heading family, I am legally married but separated and live with my 2 children, namely, and then the names of the children and their ages are outlined there, Your Worship.
Yes.
Following the separation, I am the custodial parent and primary caregiver to my minor children. They both attend school in Johannesburg. Employment. I'm currently employed or engaged as a member of parliament in the National Assembly in Cape Town, having been duly elected as such in terms of the electoral laws of South Africa during the recent May 2024 elections. As a representative of the Umkhonto weSizwe Party, which is the official opposition party in South Africa. I'm also a duly elected member of the Pan-African Parliament, in which I am the Southern Caucasus chairperson responsible for the SADC region. My income from membership of the National Assembly and other business initiatives amounts to approximately the amount stated there on average. No, under the heading, no previous convictions or pending charges. I have been informed of the provisions of section 60, bracket 11, bracket A, and state that I have no previous convictions, nor is there any other pending case against me. No likelihood to endanger public safety or commit Schedule 1 offences. I respectfully state that there is no likelihood that I will endanger the safety of the public or any particular person, nor will I commit a Schedule 1 offence should I be released on bail. The offences for which I am charged were committed almost 4 years ago under specific unprecedented circumstances which are unlikely ever to repeat themselves. Undertaking not to interfere with state witnesses, which my learned friend addressed. I will not make any contact with any state witnesses, nor have I attempted to do so. In fact, I'm not aware of the identities of any witnesses. I also understand that the major part of the evidence is based on transcripts or screenshots of social media messages rather than human witnesses, save possibly for expert and non-partisan witnesses. Any possible interference with such witnesses would be futile and senseless. No flight risk undertaking to stand trial. I respectfully state that should I be released on bail, I will stand my trial and that I do not constitute a flight risk. In this regard, I place the following on record. 1. This matter goes back as far as 4 years back. It has been lingering in the air for a long time. 2. I was fully aware of the fact that I'm being accused of instigating the well-known unrest and uprising which took place in July 2021, triggered by the widely perceived imprisonment of my father without standing trial. Many South Africans, rightly or wrongly, viewed that as an affront to our constitutional democracy and reminiscent of apartheid style that seems to be misprint. It should read apartheid style tactics. 3. Despite these allegations against me and knowing there was a high probability of a criminal case being investigated against me, I have always returned to South Africa. In the circumstances, I submit that the history of this matter clearly shows that I'm not a flight risk and that I will stand my trial in this matter. And then Your Worship will deal with the crucial matter of exceptional circumstances in terms of the section, from paragraph 26 onwards. In addition to what is stated above, this matter also exhibits the following exceptional circumstances. 1. The evidence will probably be mainly led by experts. Should be an S at the end of it. 2. Unlike all other persons who have been labeled as alleged instigators. I have a blood relationship with my own father, whose imprisonment was arguably the spark of the incidents in question. It is hardly surprising or remarkable that I was aggrieved by his imprisonment. 3, I am an elected public representative of a political party voted by more than 2.3 million voters. 4, my incarceration pending the trial, whose duration and state of readiness is unknown, would serve no purpose. 5, I have pledged to abide by my bail conditions. 6, to the best of my knowledge, no other person who has been charged with the same or similar offences has ever been convicted. Some have been either acquitted or have had their charges withdrawn. Then possible bail conditions as safeguards. I further submit that with adequate bail conditions, any fear in this regard by the state can be negated, including not leaving the country without notifying the investigating officer in this matter, which has been proposed by the state and agreed to by me. That we should be fine. And then the affordable bail amount, paragraph 28. I am furthermore able to pay an amount of 3,000 rand for bail. This is in keeping with the amount of bail paid by other persons facing the same charges in relation to the same incidents, none of whom are members of the National Assembly until 2029, as I am. In the circumstances, I respectfully submit that the interests of justice require my release from incarceration, and it's signed, Your Worship, by the accused person, and it's dated yesterday, the 29th of May. As copies, if I may just then quickly go through the notice of motion is the usual preamble, and the order that is sought, Your Worship, is that the accused be released on bail pending the trial in the sum of 3,000 rand, and such conditions as the court deems fit, including the one that I mentioned. I'm indebted to the court. As copies, if I may just check, Your Worship.
Please, certainly.
As copies.
Thank you.
Your Worship, I apologize for interrupting. There was an important oversight, and I think it's because we've waited so long for the proceedings to start. Before the accused is asked to confirm her statement, can she also be warned that any comments made in the statement may be used against her in a subsequent trial? Yes. As court, I just thought that we had forgotten this non-practice to remind the court.
Thank you, Mr. Ms. Zuma-Sambudla, please stand up. An affidavit deposed to by yourself has been handed in by Mr. Court on your behalf in support of your application to be limited on bail in this matter. In the affidavit, just after paragraph 20, actually in paragraph 21, on page 5, you disclose that you have no previous convictions and no other charges, pending charges against you. I am obliged to caution you that it amounts to a criminal offense to give incorrect information regarding your previous convictions in any country and or pending charges. Do you confirm that that information in your affidavit is indeed correct? Thank you. I am also obliged to warn you that this affidavit, the content of this affidavit, the facts that you have alluded to in support of your release on bail may be used as evidence against you at any possible trial. Do you understand that? Do you still wish this affidavit to be handed in as evidence? You're okay with that? Thank you very much. You may be seated. For the purposes of record, the affidavit by the applicant Duduzile Zuma-Sambudla consisting of some 9 pages, together with the notice of motion making 10 pages, is marked Exhibit A.
That's correct.
This is the court.
Mr. Infoco, there is one technical matter. Under regulation, I think it is 3 or 5 of the regulations under the Commission of Courts Act.
Both sectors.
Yeah. The Commissioner of Courts must put their full names and their full business address. It is a technical thing. So I see there is a stamp, but the full name appears not to be here, although the force number is here.
Yeah, yes, Your Worship. We did deal with that actually when the statement was being made, and we were assured by him, it was a him,
Yes.
that the stamp, insofar as it indicates the place, I mean, it's a broad place because it's not, is normally sufficient. But Your Worship is quite correct.
So are you requesting that I condone that in view of the stamp?
That's correct.
Thank you.
Your Worship, while I'm
Yeah, sorry, Mr. Yogi, no objection to that.
No objection, Your
Thank you.
Worship.
Thank you, Mr. Infoco.
Thank you, Your Worship. While I'm on my feet, Your Worship, would kindly request the court to order the media in the event that the statement, these days, these things go around, that the parts that were not read out in court should not be published.
Thank you.
That's good.
Mr. Bindu, no objection to that.
I have no objection to it, Your Worship. We have likewise been very careful not to include in our affidavit certain pertinent information which the investigating officer has, but to just allude to them as you will see. But I have no objection to the suggestion made by my colleague.
Can I make that ruling now?
That's the court, please.
As court, please.
Thank you. It is hereby directed that the media in all its forms is not to publish the addresses disclosed in the applicant's affidavit in support of the release on bail marked Exhibit A, as well as the names and ages of their children, which when Mr. Infoco had read out the affidavit had omitted those parts for the reason that it is not to be published. As I've understood that, because it is because of the security concern, it's in general, nothing specific. So it is hereby directed that the addresses disclosed of the applicant in Exhibit A, and I see there are some addresses in the affidavit of the investigating officer as well.
Indeed, that will also apply to that affidavit,
Yes,
Your
in
Worship.
paragraph 8, a similar directive would apply in terms of the addresses disclosed in the investigating officer's affidavit, which is yet to be read and handed in as evidence. So there shall be no publication of address. Mr. Infoco, is that the case for the applicant?
As court, please, Your Worship, that is the case for the applicant, and Your Worship, in our respectful submission, the onus has been discharged. There are certain maybe remarks that one could make from the bar, but Your Worship is aware of issues of presumption of innocence. Maybe one that needs particular mention, Your Worship, is that the case, obviously, when the trial starts, which is not mentioned in the statement, will also involve issues of Section 16 of the Constitution, freedom of expression. Your Worship knows that that provision of the Constitution obviously has an exclusion, which relates to so-called incitement of imminent violence. So, but those are debates that will be had at the trial. But that's one. Those are some of the, if you like, self-evident exceptional circumstances which arise from the law. If my learned friend has no objection.
I will give you an opportunity to address
elaborate.
on the rest, on conclusion of the entire incident. So we let the state continue now,
Yes.
and then you can address me and make submission.
Yes, subject to that, then Your Worship, that is the case for the accused, as court please.
Thank you, Mr. Kennedy.
Thank you, Your Worship. Your Worship, the investigating officer has likewise made an affidavit for presenting to the court information that will assist the court in determining the bail issue. With the leave of the court, may I read into the record? The copy was handed to Your Worship in chambers. The investigating officer, Peggy Kaya Nazu, states under oath in English, I am a colonel in the South African Police Service attached to the Directorate of Priority Crime, Directorate for Priority Crime Investigation, Serious Organized Crime Investigations, KwaZulu-Natal. The facts contained herein, unless otherwise stated or the content indicates otherwise, are within my personal knowledge and are to the best of my belief true and correct. I am not opposed to the accused being granted bail herein. The accused is facing 3 charges. Count 1, contravening section 14D, read with sections 1, 15, 16, 17, 18, and 19 of the Protection of Constitutional Democracy Against Terrorist and Related Activities Act 33 of 2004, and further read with sections 94, 256, and 270 of the Criminal Procedure Act. Further read with Part 1 of Schedule 2 of the Criminal Law Amendment Act 105 of 1997. The second count is contravening Section 18(2)(b) of the Riotous Assemblies Act 17 of 1956, read with sections 94, 256, and 270 of the Criminal Procedure Act. And count 3 is incitement to commit public violence, read with section 17 of the Riotous Assemblies Act 17 of 1958, and read with the other relevant sections that I have mentioned earlier from the Criminal Procedure Act. I was mandated by the provincial head of the Directorate for Priority Crime Investigations, KwaZulu-Natal, to investigate the civil unrest, large-scale violence, and widespread looting in KwaZulu-Natal in July 2021. The above-mentioned unrest and public violence followed the incarceration of former State President Mr. Jacob Zuma with regard to the ruling of the Constitutional Court in respect of the application brought by the Zondo Commission of Inquiry into State Capture. I am part of the team in KwaZulu-Natal that was comprised to investigate allegations of incitement, orchestration, instigating, commanding, counseling, influencing, and aiding and abetting, encouraging, instructing, and influencing a specific sector or the general public of the Republic of South Africa to commit crime, the result of which, that's awkwardly written, the result of which was riots, unrest, public violence, and large-scale damage to essential infrastructure and businesses, loss of life, fear instilled into the general public. Several social media posts were made demanding the release of Mr. Jacob Zuma and were directed to the judiciary and current President of the Republic of South Africa. These campaigns and social media posts called for the shutdown, particularly in the province of KwaZulu-Natal, forceful closure of national roads, shutdown of the economy, and large-scale extensive damage to property, threat to human life, and nationwide public violence. An affidavit of the complainant alleging that there was evidence to suggest that Ms. Duduzile Zuma-Sambudla had committed, amongst others, the acts of incitement of public violence, incitement of malicious injury to property. These were allegedly committed by unlawfully and intentionally publishing words likely to persuade, provoke, or to urge persons to violence, or producing imminent criminal offences likely to incite or produce the offences mentioned. This she did through her social media account. Further investigations support the allegations by the complainant. Paragraph 6 contains the addresses of Ms. Zuma, which were verified by the investigating officer, and he concludes that she has at least 4 bank accounts. We have the numbers in our position, Your Worship, but I have deliberately not put them into the affidavit for security purposes. She is known to be married to Mr. Zuma-Sambudla. There is no information suggesting that she is a flight risk, and it is signed and commissioned as is required. Your Worship, with the leave of the court, may that be included in the evidence as Annexure B.
Mr. Kofi, you had sight of it, of the investigating officer's affidavit.
Indeed, Your Worship, I have.
Thank you very much.
That's good, Mrs.
Thank you.
The state will not lead any further evidence.
This must be
Yep.
The affidavit by the investigating officer being now so is marked with
That's good.
As the court pleases. That is the state's evidence as far as bail is concerned. I will address your worship if necessary on any other issue.
Thank you very much.
Thank you, Your Worship. I'm indebted to Your Worship. Yes, Your Worship, in our respectful submission, the affidavit sufficiently addresses the requirements of the law. In particular, as Your Worship well knows, that in addition to the so-called ordinary circumstances, flight risk and the usual, in terms of section 6011A, the accused person also bears the extra onus of establishing exceptional circumstances. In our case law, to paraphrase Your Worship, it has been said that sometimes even the so-called ordinary circumstances in a particular case become exceptional. So what we have done is to set up what I would refer to as the ordinary circumstances, but separately then set up the exceptional circumstances. But from Your Worship's point of view, Your Worship would implore the court to view those circumstances holistically. In that regard, then Your Worship, were of the view that the onus has been discharged. Particularly, as my learned friend indicated, there has been a very cooperative relationship between us and the state, and so indications were already made informally even before we got their affidavit about the attitude of the state to bail. The only other issue, Your Worship, just for the record, is the contextual constitutional setting that I referred to. As I said, that we would implore Your Worship to keep in mind in assessing the evidence before you that contextual setting, which is characterized firstly by the presumption of innocence. I don't need to elaborate as to the implications of that in respect of bail, but as I said, more specifically, the very worrying issue about freedom of expression, to the extent that it is common cause that this entire case is really founded on expressions made by the accused on social media. And as I said, Your Worship, we do acknowledge that there's no such thing as freedom of expression to do anything, and therefore that is why this is section 16(2) of the Constitution. But Your Worship, in our respectful submission, there's no suggestion that that section applies, but that's a matter that will be debated hopefully at length during the trial itself. Other than that, Your Worship, there's nothing more to add. We would therefore implore and pray that the court grants bail to the required amount.
Thank you, Mr.
But the entire business of this case is rather bizarre, particularly in relation to the length of time that it has taken, as indicated in the statement, simply to inspect what are 4 or 5 or whatever number of social media posts. Surely that's not an exercise that should take even 4 hours, let alone 4 years. But be that as it may, Your Worship, we appreciated that for whatever reasons, legal and illegal, depending on what will be found by the High Court when those issues are explored. The state saw it fit to succumb, for lack of a better word, to some pressure either from the complainant or other protests by doing what it did 4 years later. But on the specific issue of the arrest, Your Worship, I must say that maybe in favor of the state, that particularly given my own interactions for the past 10 days or so with the investigating officer, Colonel Nazo, and then subsequently my learned friend, as Your Worship has remarked, the attitude has really been professional. The matter has been handled professionally. So without putting words into the mouth of my learned friend, I would assume that the issue of the arrest per se was really for procedural and technical purposes. And for what it's worth, I was present throughout the procedures, even the fingerprinting procedures. And there was really, it was a matter of, in fact, our terminology was that it's processing. But I suppose, to be technically correct, one could say that there was an arrest. And as indicated by my learned friend, the accused cooperated throughout the period. So we really don't take much issue with that. There was, as far as that is concerned, that was not a particularly onerous provision. But I must qualify that, Your Worship. That is not to say that we are not seriously, that the accused is not seriously aggrieved by the prosecution itself. So we don't want one day somebody to say, oh, but you said it was all fine. No, it's not all fine. Even the comfortable arrest and processing was uncalled for. This whole thing is just a waste of the state's time and everybody's time. That's the problem. That will be our attitude at the moment.
Thank you, Mr.
You know, I'll deal with the issue of the accused being brought to court under arrest as it has happened. Your Worship, the nature of a charge that an accused is charged with determines the schedule in which bail applications are heard. And the schedule in which a bail application is heard brings about different things. If it's Schedule 5, there's a different onus to be dealt with, and Schedule 6 has a different onus. Now, in Schedule 6, the onus rests upon an accused to do so. In this case, the accused is charged with the Schedule 6 offense, as we've agreed. Now, when it comes to the bail process is an inquisitorial process by the presiding officer. Ultimately, the decision to grant bail or not rests with the presiding officer. Even if the state is not opposed to bail for an accused, the presiding officer can say, nonetheless, I find that you have failed to discharge your onus of showing exceptional circumstances exist in the interest of justice, and therefore refuse bail. Now, Your Worship, a court cannot make that consideration for an accused who is brought before the court who is not under arrest. A court can only make that consideration when an accused is brought under arrest. If an accused is brought here by summons, we then deprive the court of the right that it has, of the duty that it has, to make that inquisitorial finding regarding bail. And so, what we then chose to do, and that is to secure the attendance of the accused in the circumstances of a Schedule 6 case with in the least imposing way on the accused. And that was to do it as we did. We phoned the accused through her legal representatives. We made arrangements for her to be brought and to be placed.
Implicit in the submission by the state is that perhaps it has some degree of symbolism attached to it. I don't think the court should be in the business of making orders which are symbolic. We should be dealing with the matter as the facts appear before us and having invited parties to make a submission beyond. I therefore decline to fix an amount of bail. In terms of Section 72 of the Criminal Procedure Act, I think all the circumstances in this case point to you being released on warning in terms of Section 72 of the Act.
As the court pleases, Your Worship.
Yes, please, Mr. President.
Your Worship, I have an indictment which needs to be served upon the accused. The date for transfer to the High Court is 20th March 2025.
Ms. Zuma-Sambudla, do you confirm that you received the indictment? Okay, and it contained the summary of substantial facts and the list of witnesses. Thank you very much. I confirm that it has been duly served. Ms. Zuma-Sambudla, the matter is transferred to the Durban High Court, which is currently just housed in the opposite end of this building. I see there is no court specified, but I'm sure Mr. Important will assist in that regard. For the 20th of March this year, at 8:30, the matter is being postponed as a provisional date. So, depending on what happens, the matter will then be adjourned either for a pre-trial and then a trial, but depends what happens. But please report to court at the Durban High Court on the 20th of March this year at 8:30. Should you fail to appeal, a warrant for your arrest will be authorized and you may then be kept in custody pending finalization of this matter. Do you understand the Zuma-Sambudla? Do you understand? Thank you very much.